Good, good morning, and welcome to our UBC Learning Circle, Reclaiming Anishinaabe Law, Recognition and Affirmation as Reconciliation. Today's conversation is presented in partnership with the Center for Excellence in Indigenous Health. We'd like to thank the First Nations Health Authority for generously funding the UBC Learning Circle and allowing us to have these conversations. Before we formally begin, I'd like to acknowledge with respect and gratitude that I'm joining you from the unceded territories of the Musqueam, Squamish, and Tsleil-Waututh nations. Please feel free to introduce yourself and the nation you're calling in from in the chat box. And for those of you who don't know me, my name is Saraid Walken. I am the Learning Circle Manager. I am Silk Okanagan on my mother's side and Hickory Apache and Belgian on my father's side. Um, I will be the moderator for today's discussion, and joining us working behind the scenes is our program assistant, Kira. She'll be in the background interacting with everyone in the chat. And finally, before we get into today's discussion, I will provide a gentle heads up that today's topics may be sensitive or emotionally triggering. Please make sure that you're looking after yourself, and if at any point in time you need to talk to an elder, friend, counselor, or family member, don't hesitate to do so. Now I'll turn it over. We have some prompts in the chat if you need additional support. Now I'll turn it over to our guests to introduce themselves. Thank you. Here, I'll pass it to you, Leo.
Just sharing my screen here. Hopefully, all I can see that. Bojo, Ojawaska said, Binasa Indigenous cause like the Konji Adiki Dodam. Before I begin, I think it is important to make clear that my decision to introduce myself in my native language, Anishinaabe Moen, actually represents a conscious and explicit act of self-determination as well as cultural insurgence, or excuse me, cultural resurgence. The truth is, I'm not actually fluent in Anishinaabe, and the primary reason for that is because there are still systemic forces that have been imposed by a settler colonial state that still exist, which are specifically designed to erase Indigenous identity, as well as the state's constitutional treaty obligations in order to facilitate the dispossession of land and inherent rights of Indigenous peoples. With that said, my name is Leo Baskatawang, and I am an assistant professor in the Faculty of Law at the University of Manitoba. And I wish to thank you for tuning in to my presentation on reclaiming Anishinaabe law. I am indeed Anishinaabe from Lac du Mille First Nation, and I am a member of the Caribou clan. So it is a great honor for me to be here today. So I wish to thank Miss Surrey and Squawkin for inviting me to be part of the UBC Learning Circle series. My understanding that my task today is to help you all think about ways in which we as Indigenous people can implement our own Indigenous laws in our own communities and have them recognized and affirmed by Canadian governments. With that said, my talk today will be about the work I did with the Grand Council Treaty 3 back in 2018 and 2019, in which we attempted to come up with a draft Treaty 3 education law, which is called Kinemaduan Inakanagewin. And so for those of you who don't know, the Grand Council Treaty 3 is the traditional government of the Anishinaabe Nation, which is in Treaty 3 territory. And this work I did with them ultimately became the subject of my book, Reclaiming Anishinaabe Law, which was published last year by the University of Manitoba Press. Okay, so with that introduction out of the way, the first thing I want to mention about my research on reclaiming Anishinaabe law and the book that followed is that all of my work is, in fact, dedicated to the people of the Anishinaabe Nation in Treaty 3. And as a member of that nation, I know from firsthand experience about the tremendous harms and injustices that many of my people have suffered at the hands of the Canadian government as well as its institutions over an extended period of time, pretty much since our treaty was first negotiated back in 1873. My research is therefore partly meant to give a voice to that legacy of injustice, but more so, I'm hoping it represents a beacon of hope on how we can move forward as a society in the spirit of reconciliation. On that note, I should mention that I think it's also important for anyone who wishes to conduct research in this field with Indigenous communities that they understand that it is absolutely critical that their research and the methods that they employ are used for the benefit of the nations and communities that they choose to work with. I say this because it happens far too often that researchers will go into Indigenous communities, take what does not belong to them, and either distort it or misrepresent it, and ultimately harm the very people who had helped them. So, to put it bluntly, that must not happen. And so, with that said, in order to understand the legacy of injustice that so many Indigenous nations have endured and how we might move forward together with the rest of Canada, I think we must first understand the processes of colonization and assimilation, as well as understand how they operate and why. Fortunately, oh, there we go. So, with regard to colonization, Albert Memmi, in his seminal book, The Colonizer and the Colonized, points out that colonization is actually constructed from three major ideological components. One being the gulf between the cultures of the colonizer and those of the colonized. The second component being the exploitation of those differences for the benefit of the colonizer. And third, the use of these differences as standards of absolute fact and consequently to justify their exploitation. Um, the main difference between colonizers and the colonized, according to Albert Memmi, that was used to exploit indigenous peoples was an attitude towards land. So whereas indigenous peoples have historically lived off the land in a sustainable way, such that there was very minimal environmental impact or disruption, Western civilizations, on the other hand, viewed the land more as a commodity, um, which is to say that it was something that could be transformed and used for profit, which is to also say for the accumulation of personal wealth. And in one of the more memorable passages of The Colonizer and the Colonized, Memmi describes this difference in ideology as such, and I quote, "Nothing could better justify the colonizer's privileged position than his industry, and nothing could better justify the colonized destitution than his indolence. The colonized doesn't let grass grow under his feet, but a tree. And what a tree! A eucalyptus. No, an American centenarian oak. A tree? No, a forest." End quote. So here, the implication, of course, is that improving or cultivating the land is considered to be a good thing by the colonizers and is in fact a mark of civilized culture, whereas others who remain in a state of raw nature are considered to be primitive and uncivilized. Similarly, when European agents of colonization first arrived in North America and saw that the indigenous peoples with whom they encountered appeared to have no written laws, this was used as justification to enact colonial laws and thereby claim sovereignty over the lands on which they found themselves. Any resistance to that practice was then met with punishing and lethal force. In fact, in his book called Fair Country, John Ralston Sauls also points out that in the late 15th century, there were perhaps as many as 7 to 10 million indigenous peoples living across Turtle Island, 2 million of which were here in the territory now considered to be Canada. And that by the end of the 19th century, there were approximately only 250,000 indigenous peoples left in the United States and approximately 100,000 in Canada, which represents approximately a 95% depopulation of indigenous peoples across the continent. Um, so, in grappling with the theory of colonization and its manifestations, some indigenous scholars have compared it to a being in our oral traditions known as the Wendigo. Leanne Simpson, for example, writes that the Wendigo is an entity that has an insatiable hunger and appetite for natural resources to the extent that it will try to consume everything to the point that it eventually even destroys itself through over exploitation. Anishinaabe legal scholar John Burroughs has also written that Wendigos can either be institutions or individuals who prey on indigenous social, economic, and political infrastructures for their own material gain. And this is, in fact, accomplished by the colonizers' production and control of ideological apparatuses such as churches, schools, and courts of law, all of which enable the cannibalizing culture to establish and maintain a cultural hegemony over indigenous peoples. So, with that said, this brings me to the concept of assimilation, which can more politely be described as a process in which one culture is absorbed into another. But in a colonial context, it's not nearly as innocuous as that. Quite the contrary, actually. The assimilative process is actually quite violent in a colonial context, to the extent that there is a willful intent by colonial agents to systematically deconstruct and even destroy an indigenous nation's culture for the sole purpose of erasing the state's fiduciary responsibilities that it owes to indigenous nations. As a reference to that point, I I often consider the work of Pamela Palmater, who is a leading Indigenous legal scholar in Canada, who has written, and I quote, "The ultimate objective of early Indian policy was to access Indigenous lands and resources, and at the same time, to reduce the government's financial obligations to Indigenous peoples, and their methods were far from benign. From scalping laws to forced sterilizations to residential schools, and now the Indian Act's registrations provisions, the methods chosen to achieve those policy objectives have focused more on eliminating Indians rather than assimilating them." End quote. To Palmater's point, Indigenous scholars often cite a statement made by Duncan Campbell Scott, which was made back in 1920, who said, and I quote, "I want to get rid of the Indian problem. Our objective is to continue until there's not a single Indian in Canada that has not been absorbed into the body politic, and there is no Indian question and no Indian department. That is the whole object of this bill." And while it should be acknowledged that statement was made over 100 years ago. It's also worth noting that in 1983, Pierre Elliott Trudeau, who was serving as Canada's prime minister at the time, also made a statement, which was done at the First Ministers Conference, and could easily be considered quite as contentious as Campbell Scott's. Um, With that said, Trudeau said, and I quote, "If you no longer speak your language and no longer practice your culture, then you have no right to demand Aboriginal rights from us because you are assimilated with the ruling power." And even more recently than that, Stephen, former Prime Minister Stephen Harper also made a claim that Canada has no history of colonialism. So this is to say that all along, many politicians in Canada across many generations have denied not only colonialism, but also their responsibilities to Indigenous people. Now, as I previously alluded to, the Indian Act was and arguably still is the key instrument in the assimilation of Indigenous peoples here in Canada. At one time, it banned Indigenous ceremonies. It also invoked involuntary enfranchisement policies. And it, of course, made attendance at residential schools mandatory. While those elements of the Indian Act may be gone, it nevertheless continues to place restrictions on forms of Indigenous governance and other customary practices, as well as continue to dictate requirements of Indian status. In addition to the Indian Act, however, there are other things happening in Canada that also contribute to the involuntary assimilation of Indigenous peoples. One of which is the 60 Scoop, where Indigenous children were apprehended by Child and Family Services agents who were then placed into non-Indigenous homes, which oftentimes resulted in the severing of their connection to family, community, and culture. And that practice actually continued into the 1980s. Apart from that, there is also the public education system in Canada, which for many decades excluded Indigenous history and culture, whether that may be languages, ceremonies, or other customary practices from its curricular offerings. It almost goes without saying that during those dark years, Indigenous people were rarely considered for teaching, administrative, and support staff positions. That is to say, for Indigenous students who went to school in the public school system, which is the vast majority of us today, we did not learn anything about our culture and consequently have become assimilated into mainstream Canadian culture. And I'm here today to tell you that I am also one of those students. As we now know, the assimilative agenda has had disastrous effects on Indigenous families and communities, which is marked by lower rates of educational success, which then translates into poverty, and addictions, which sometimes also manifests into domestic violence and other sources of crime. So it is these circumstances that have prompted the Anishinaabe leadership within Treaty 3 territory to establish the Treaty 3 Anishinaabe Education Secretariat in 1991, which had a goal of designing, implementing, and eventually controlling our own Anishinaabe education system. In conjunction with that initiative, Treaty 3 elder Fred Kelly, who has since become a nationally recognized and esteemed leader throughout Indian country, And he wrote a report in which he argued that it is the responsibility of the Grand Council Treaty 3, um, in cooperation with the federal and provincial governments of Canada, to facilitate the recognition of a Treaty 3 education law. Now, at this point, I think it's important that I take a moment to discuss how law is conceived and observed by the Anishinaabe Nation Treaty 3, because within our nation, there are four orders of law. So the first order of law is called Kigagwe Inakinagewan, which loosely translates to sacred law. And this is really the basis of an Anishinaabe constitution. The sanctity of the sacred law has been and continues to be preserved in our oral traditions for many generations. Um, this means that it is forbidden to be written or codified. And while that may seem unusual, I would remind you that there are, in fact, other nations, including the United Kingdom, whose constitution is also uncodified. With that said, Anishinaabe elders believe that our sacred law provides our people with instructions on how to live the good life, Mino Bimadzuin. Um, and this is in accordance with the seven sacred teachings. With that said, it also teaches us about how to use medicine, how to apply science, how to teach the next generation, to learn about healthcare, food security, how to interact with others through economy and trade. It teaches us about how to take care of the environment and the land we live on, animal harvesting, fishing, water conservation. Um, and these are just a few examples on which our Constitution is based. Um, in other words, our sacred law provides the Anishinaabe Nation and Treaty 3 with our worldview and the knowledge with which to sustain our way of life on the land. So the second order of Anishinaabe law is Keti Inakanagewen, or traditional law. So similar to sacred law, Anishinaabe traditional law is also not to be is not permitted to be written or codified. Ketianakinagewin is typically maintained and observed by members of the Medewan Society, which is composed of Anishinaabe elders and traditional knowledge holders who participate in ceremonial practices such as the sun dance, sweat lodge, and shaking tent. And I will quickly add that some of the practices of the Midewin Society are among those that were actually banned by the Indian Act. So for many years, the Midewin Society had to practice our traditional laws in hiding. But these laws are never, but these, but the Medewan Society is nevertheless dedicated to the preservation and protection of Anishinaabe traditional laws and knowledge, as well as to the maintenance of cultural protocols and ceremonies and other special events. The third order of Anishinaabe law is Anishinaabe Inakanagewin, which translates to customary law. Anishinaabe customary law is most often practiced by community members who still maintain a strong connection to the land through the maintenance of customary practices such as fishing, hunting, trapping, and food harvesting. It is worth noting that some important principles of Anishinaabe and Akinagewin are also key reference points to how we live on the land, which includes do not take more than what is needed, use all of which is taken, hunt and fish during the appropriate seasons, and ensure that the next generation can also enjoy the bounty of the land. Unlike sacred and traditional law, which are deeply rooted in tradition and creation, Anishinaabe and Akanigewin actually can be adapted for contemporary circumstances. And therefore, some aspects of it might actually be written down, as opposed to being strictly maintained through ceremony, storytelling, and other traditional practices. With that said, the fourth order of Anishinaabe law is Ojibige and Akanigewin, which translates to written temporal law. As the fourth order of law, um, Ojibige and Akanigewin is distinguished by its phonetic form of representation, which is to say its written form. Although its primary purpose is to try to bring harmony um, with the administration of other laws, such as those of Canada, um, this fourth order of law, nevertheless, must conform to and be consistent with all of our other principles, with all of the other principles that are inherent into that are inherent in the other three orders of Anishinaabe law. Um, as of today, um, the Grand Council Treaty 3 has ratified really only one written temporal law, which is Manitou Aki Anakinagewin, which translates to the Great Earth Law. Um, but Grand Council is also in the process of codifying a few others, including a healthcare law and also a childcare law, as well as an education law, which is the focus of my research. With regard to the Treaty 3 education law, the main purpose of it is to delineate the main principles of our education system, but also to inform the federal government of Canada our understanding and interpretation of the treaty right to education, as well as further the process of reconciliation that has been established by the Truth and Reconciliation Commission of Canada. But before I get into the Treaty 3 education law itself, I'd like to take a moment to discuss the treaty right to education and how it intersects with Canadian case law, as well as the United Nations Declaration on the Rights of Indigenous People. So, the education clause in Treaty 3 and as well as in the other numbered treaties, is actually a rather nondescript line that states, and I quote, and further, Her Majesty agrees to maintain schools for instruction in such reserves hereby made as to her government of her Dominion of Canada may seem advisable whenever the Indians of the reserve shall desire it. In my view, there are two key elements to observe in that clause. One is the notion that schools will be maintained by the Crown, and the other is that schools will be made whenever the Indians of the reserve ask for them, or more specifically, whenever they desire it. So, with that being said, treaty elders have long maintained that the education clause simply meant that the Canadian government would provide schools whenever the Indians of the reserve asked for them. Indeed, if we look outside the text of the treaty, this interpretation of the education clause is reinforced by the treaty commissioner Alexander Morris himself, who transcribed the negotiations of the treaty in his book, The Treaties of Canada. And he actually recorded himself as stating, and I quote, I will also establish schools whenever any band asks for them, so that your children may have the learning of the white man. Yet, when it has come to fulfilling the promise of the treaty right to education, government officials have relied on a singular word in the education clause, which is advisable, meaning that the schools would only be established on reserve if it seems advisable to the state. Now, while it is difficult to imagine a situation where it would be inadvisable to build a school in any community, it bears repeating that Indigenous leaders have always thought that the Education Clause was meant to ensure that our people would receive an education whenever they desire it, and that the state would pay for it regardless of the advisability of that undertaking. The worst part, though, is that it seems that the Canadian government saw the Education Clause as a means to justify the establishment of the Indian residential school system so that it can fulfill its obligation to educate Aboriginal or excuse me, in order to fulfill its obligation to educate Aboriginal children, which is a quote from former Prime Minister Stephen Harper's residential school apology back in 2008. To that point, all I can say is that it should be fairly obvious that when Indigenous leaders negotiated the education clause in the numbered treaties, that they did not think that the Canadian government would take that to mean that the government and its agents would have the right to forcefully remove Indigenous children from their homes, strip them of their cultural identity, and then assimilate them to the norms and values of a settler colonial society. With that said, in the last 40 years, since the creation of Section 35 in the Constitution Act, many cases have come forward to get recognition and affirmation on the nature and scope of Indigenous peoples' treaty rights. And while most of those cases have centered on the issue of hunting and fishing rights, the principles of treaty interpretation that have been established by the Supreme Court of Canada actually might be an instructive way on how the treaty right to education should be viewed. So, in a dissenting opinion of the 1999 Supreme Court case R.V. Marshall, for example, Justice Beverly McLaughlin made a point of listing 9 principles of treaty interpretation that were drawn from previous case files, which are meant to help address the issue of treaty interpretation. According to Justice McLaughlin, these are the principles to which the Supreme Court ought to interpret those treaties. Number one, Aboriginal treaties constitute a unique type of agreement and attract special principles of interpretation. Number two, treaties should be liberally construed and ambiguities or doubtful expressions should be resolved in favor of the Aboriginal signatories. Number three, the goal of treaty interpretation is to choose from among the various possible interpretations of common intention, the one which best reconciles the interests of both parties at the time the treaty was signed. Number four, in searching for the common intention of the parties, the integrity and honor of the crown is presumed. Number five, in determining the signatories' respective understanding and intentions, the court must be sensitive to the unique cultural and linguistic differences between the parties. Number six, the words of the treaty must be given the sense which they would naturally have held for the parties at the time. Seven, A technical or contractual interpretation of treaty wording should be avoided. Number eight, while construing the language generously, courts cannot alter the terms of the treaty by exceeding what is possible on the language or realistic. And finally, treaty rights of Aboriginal peoples must not be interpreted in a static or rigid way. They are not frozen at the date of signature. The interpreting court must update treaty rights to provide for their modern exercise. This involves determining what modern practices are reasonably incidental to the core treaty right in its modern context. So, at first glance, um, these principles of treaty interpretation um, seem fair and reasonable, but the reality is they're far from complete. Worse yet, one of the principles actually appears to be drawn from an 1899 United States Supreme Court decision called Jones v. Meehan. And in that case, the judge famously stated, and I quote, in construing any treaty between the United States and an Indian tribe, it must always be borne in mind that the negotiations for the treaty are conducted on the part of the United States, an enlightened and powerful nation, by representatives skilled in diplomacy, masters of a written language, understanding the modes and forms of creating the various technical estates known in their law, and assisted by an interpreter employed by themselves, and that the treaty is drawn up by them and in their own language, and that the Indians, on the other hand, are a weak and dependent people who have no written language and are wholly unfamiliar with all the forms of legal expression, and whose only knowledge of the terms in which the treaty is framed is that which is imparted to them by the interpreter employed by the United States. The treaty must therefore be construed not according to the technical meaning of its words to learned lawyers, but in the sense in which they would naturally be understood by the Indians. So, after seeing and hearing that, it should be quite obvious that there are two sides of the story here. We can see that there is the enlightened and powerful nation, which is the United States, while on the other hand, we have the Indians, who are a weak and dependent people. Secondly, as far as the United States, and I think Canada should also be included in this analysis, being masters of a written language in relation to Indigenous nations who are supposedly wholly unfamiliar with all the forms of legal expression, this serves as a prime example of the racial and ideological bias that exists within the justice system as it relates to Indigenous people. The point here is that this tactic of juxtaposition between two cultures is a literal manifestation of what Albert Memmi talks about in his book that I pointed out earlier, as well as the Civ-Sav dichotomy, which was first coined by Professor Emma LaRocque in the Department of Native Studies here at the University of Manitoba. According to Professor LaRocque, the Civ-Sav dichotomy is, and I quote, the systemic construction of self-confirming evidence that natives were savages who inevitably had to yield to the superior powers of civilization as carried forward by Euro-Canadian civilizers. Or to put it another way, Western or settler colonial society is consistently represented in text as being progressive, industrious, and civilized, whereas indigenous nations and people are almost always represented as being timeless, uncultivated, illiterate, and of course, savage. This dichotomous relationship that I'm describing is actually defined by the difference between the colonizers and the colonized and the corresponding consumption of such difference. In the consumption of difference of the other, which is accomplished through laws and policies that, again, are designed to erase indigenous knowledge and identity, the cannibalistic nature of colonization and its assimilative project is actually revealed. To put it differently, the forces of colonization, whether it's the courts, the schools, or even the church, they are a Wendigo that are hungry for indigenous lands and people. Um, with that said, I do wish to acknowledge that Justice Gray, in that Jones v. Meehan decision, does make a critical point that treaties must be construed as they would naturally be understood by the Indians, given the fact that the state had every other conceivable advantage in the treaty negotiation process. And it seems to be from that sentiment where Justice McLaughlin concedes the point that treaties should be liberally construed and ambiguities or doubtful expressions should be resolved in favor of the Aboriginal signatories. So, in reviewing Justice McLaughlin's other principles of treaty interpretation, another element that is consistently woven through is this idea of common intention, which in practice has actually been very difficult to determine. Up until recently, the courts have most often relied on a written text, a written version of the treaty, which has been described by M.A. Kraft, who is also an Anishinaabe Métis legal scholar, says gives undue weight to the Crown perspective and puts the Crown signatory in the privileged position as the legislator. Thus, in order to understand the common intentions of the signatory of a treaty, it is important to consider whatever extrinsic evidence that might be available, which is exactly what Chief Justice Antonio Lamer described in the 1997 Delgamuukw decision when he wrote for the majority and said this. Notwithstanding the challenges created by the use of oral histories as proof of historical facts, the laws of evidence must be adapted in order that this type of evidence can be accommodated and placed on an equal footing with the types of historical evidence that courts are familiar with, which largely consists of historical documents. Now, as you can imagine, that idea had been argued by Indigenous peoples long before this decision came about. But once it was finally recognized, it was indeed embraced and celebrated by Indigenous peoples all across the country. As one example, Leonard Rotman um, had since elaborated on this idea, stating that treaties are time and context specific and must be examined in the light of circumstances under which they arose, including the Crown's and the Indigenous people's understanding of their terms. One must observe their spirit and intent, which includes the substance of the negotiations between the Crown and the Indigenous peoples leading up to the conclusion of the treaties. So, in other words, what was said and done at the negotiation table is just as important as the treaty itself, and that needs to be recognized. Moreover, when we are trying to interpret a treaty, we should also bear in mind what Justice Corey said in the 1996 Badger decision when he stated that treaties represent an exchange of solemn promises between the Crown and various Indian nations, and that the honor of the Crown is always at stake to the extent that it must be assumed that the Crown intended to fulfill its promises, and perhaps most importantly, that no appearance of sharp dealing will be sanctioned. In light of this view, and with regard to treaty rights that have not yet been implemented, such as education, I return to Justice McLaughlin's principle that treaty rights of Aboriginal peoples must not be interpreted in a static or rigid way. They are not frozen at the date of signature. The interpreting court must update treaty rights to provide for their modern exercise. This involves determining what modern practices are reasonably incidental to the core treaty right in its modern context. So, in considering that principle, it doesn't really take much imagination to envision that the education clause might mean that it would be advisable of the state to fund an Anishinaabe education system whenever their treaty partners desire it. A simple interpretation such as that um, is one that would be and guided by the spirit and intent of the original treaty relationship, and one that respects inherent rights, treaty jurisdictions, and one that respects the decisions of our courts, which is exactly what had been articulated by Prime Minister Justin Trudeau himself during his election speech. In mentioning Justin Trudeau, I wish to take this opportunity to remind you that back in 2015, that he was elected in no small part because he promised to fulfill the Truth and Reconciliation Commission's 94 calls to action, as well as to implement the United Nations declarations on the rights of Indigenous peoples, which brought record numbers of Indigenous peoples to the voting polls and ultimately got him elected. UNDRIP, I think, is particularly important because a few of its articles are directly related to the recognition and affirmation of Indigenous laws and education system. For instance, Article 5 of UNDRIP affirms that Indigenous peoples have the right to maintain and strengthen their distinct political, legal, economic, social, and cultural institutions while retaining their right to participate fully, if they so choose, in the political, economic, social, and cultural life of the state. Also, given that Indigenous nations understand the treaty relationship in accordance with our own principles and systems of law, UNDRIP also provides a foundation to enact and enforce those laws in matters relating to the treaty. Article 37, in particular, states that Indigenous nations have the right, and I quote, to the recognition, observance, and enforcement of treaties, and that states must honor and respect such treaties, agreements, and other constructive arrangements. Moreover, Article 18 of UNDRIP states that Indigenous peoples have the right to participate in decision-making matters which would affect their rights through representatives chosen by themselves in accordance with their own procedures, as well as to maintain and develop their own Indigenous making institutions. With regard to education, Article 14 of UNDRIP states, and I quote, Indigenous peoples have the right to establish and control their education systems and institutions, providing education in their own languages in a manner appropriate to their cultural methods of teaching and learning. So, given that the government of Canada has failed to develop an education policy that respects the cultures of Indigenous peoples, the implementation of UNDRIP represents an incredibly strong catalyst with which to provide Indigenous nations the opportunity to establish their own education systems in accordance with their own laws and principles in a way that is enshrined in Canadian law, being that all Indigenous nations have their own decision-making institutions that have the capacity to govern and administer the laws of their own people. With that said, I must admit that I think Canada has made significant strides towards implementing UNDRIP over the past couple of years, um, considering that they released a national action plan in June of last year. In doing so, it seems now that the Canadian government might finally recognize the severity of the harms it has done to Indigenous peoples, and that there is a genuine political interest to atone for its negligence and gross misconduct. And if that is true, then I think we could be embarking on an unprecedented opportunity for Indigenous nations in Canada to reclaim control of over the governance of their communities in a way that has not been enjoyed since the introduction of the Indian Act back in 1876, especially when it comes to education. In order for that to happen, however, it is my opinion that Indigenous nations will need to accept that they have a responsibility to present their laws in a way that can be recognized and understood by Canadian governments, which is to say that at least some of those laws need to be written down. Um, And I think personally that education has to be one of those laws that is recognized and understood, particularly because of how harmful Canadian education policies have been to Indigenous peoples in the past. It should be understood, however, that there is a prevailing sentiment among many Indigenous people that we owe the Canadian government nothing and that there's no good reason to trust the government. But from my perspective, I do not see how we as Canadians can coexist as a society in a spirit of peace and goodwill, as was stated in the treaties, if we do not learn to effectively communicate with each other. With that being said, I think that if an education system is to be established as the implementation of the treaty right to education, then it must be recognized and affirmed that it will be the Indigenous nations who sign treaties that will articulate the standards, curriculum, and govern general governance of the education system in accordance with our own laws to not only meet our education needs, but to also further promote our own healing and self-determination. Finally, with the few minutes I have remaining, I would like to briefly discuss how I think a Treaty 3 education system would differ from the public education system in Canada and how it could potentially be administered in accordance with our own education law. So the Treaty 3 education law, as presently constituted, is actually pretty detailed in terms of articulating where the authority of the law comes from, what the Treaty 3 education standards and local curriculum will be, and how that education system will be financed. In terms of authority, the Treaty 3 education law, well, the draft Treaty 3 education law states that the education is a matter of Anishinaabe sacred law, where the legislative, executive, and administrative jurisdiction of education is vested in the membership of the Anishinaabe Nation in Treaty 3, who are the rights holders and are represented through its leadership in the Grand Chief of the Grand Council Treaty 3. Beyond that, the draft law also states that our right to education was recognized and affirmed by the signatories of Treaty 3, and that corresponding case laws and international declarations, such as UNDRIP, further recognize our right to education, further recognize our right to administer our own education system. In order to facilitate that process, the elders of Treaty 3 then agreed that a Treaty 3 Education Commission would need to be established that effectively administers and better communicates the elements of the education law with other forms of government in conjunction with the consensus of its constituent communities. A little bit of alliteration there for you. um, so that is to say, the Treaty 3 Education Commission would communicate with Treaty 3 communities, learn what their concerns and priorities are with respect to education, and articulate those concerns to other governing bodies, such as the federal and provincial governments of Canada, as well as address those concerns in the administration of the education law. In fact, one of the first responsibilities of the Treaty 3 Education Commission would be the formulation of policies, procedures, and regulations to guide the application of a written education law. This work includes the development of a Treaty 3 education plan, a code of conduct, curriculum, and education standards. The Treaty 3 education law also has a section dedicated to our language, stating that Anishinaabe will be the official language of work to the extent that all staff and administrators will use the language to the greatest extent possible, including using it as the language of classroom instruction. I have to admit that objective will undoubtedly be difficult to implement if we consider the deleterious effects that the residential school system has had on our people. But it is also one that I think is integral to the revitalization of our language. Similarly, the education law also states that traditional ceremonies and practices will be taught in our education system to the students. Um, this process includes the teaching of our oral tradition and local history, as well as the inclusion of land-based practices such as fishing and hunting, which includes teachings about living sustainably off the land. And that idea actually speaks to another aspect of the Treaty 3 education law, which is the participation of community members. In the past, the lack of community participation in Canadian schools um, has been an ongoing, steadfast complaint of Indigenous leadership that goes at least as far back as the Indian Control of Indian Education report from 1970, which was the National Indian Brotherhood's official response to the Canadian government's proposed white paper policy. In response to that concern, the draft education law states that parents, guardians, and community members may form a community education council to bring their recommendations to the Treaty 3 Education Commission. So, in addition to providing guidance on policy development, members of the Community Education Council will also be involved in the hands-on learning of Treaty 3 students by providing instruction on land-based learning, oral history, cultural and spiritual knowledge, as well as cultural mapping of the territory. They can also serve as a mediator in instances of student misconduct prior to any case being advanced to, say, the Treaty 3 Education Commission for any sort of disciplinary action. Finally, one other aspect I want to touch on about the Treaty 3 education law is that it also provides that our education standards will either be the same or better than provincial standards, and that our expectation is that the funding for the education system will comply with those standards. From our perspective, that would be in accordance with the spirit and intent of the treaty our ancestors signed, as well as in view of the Canadian government's public commitment to reconciliation. As a nation, we in the Anishinaabe Nation in Treaty 3 understand that there will likely be many challenges ahead in this process. As such, we can only hope that Prime Minister Trudeau will honor the promises he has already made, since he is on record as stating, and I quote again, a respectful, cooperative partnership is not only possible, it is a sacred responsibility inherited to us from past generations and entrusted to us by future ones. I promise you that I will be your partner in the years to come and hope that you will be mine. We have much work to do together. End quote. I personally think it is essential that the Prime Minister, as well as future administrations of Canadian government, are taken to task on that commitment. In more ways than one, the peace and goodwill of the country we all live in depends on it. In closing, being that I have often been asked how these developments in Indigenous education might be paid for, I thought I would offer a couple of suggestions. One of which is not very popular. Uh, and that one is to create a new reconciliation tax that would be added to the GST, which I think has symbolic import as it does material, in the sense that each and every Canadian would be contributing to the reconciliation process, however small that contribution might be. For example, if we consider that the Canadian government currently collects over $40 billion every year on 5% GST, even just a 1% increase to GST could generate approximately $8 billion every year that could be used to support Indigenous education or other Indigenous nation building programs. Um, Another idea, which is um, probably just as important and maybe even more important, is that to settle on a share of revenue from the taxes that are gathered from land-based industries, or to just basically tax those industries more. Collectively, these corporations generate billions of dollars in profit every single year. And therefore, I think it makes sense to have the wealthiest pay their fair share to those in need, and in the process, also recalibrate the distribution of wealth. Um, I think that pretty much covers it. I wish to thank you for listening, and I am happy now to take any questions or comments that any of you might have.
Thank you so much, Leo. That was amazing. It was great to learn about all the different treaty things that you were sharing, and how it applies to Anishinaabe law and whatnot. And we actually have quite a few questions here. First question is, I think it was in reference to the slide on the Anishinaabe laws. I think the four ones. Uh,
Okay.
it's the question says, are these categories of law largely similar or different among the smaller groups that make up the Anishinaabe?
That's a good question. Um, there's a lot to unpack in that question, and I do talk about this in my book. But the fact of the matter is, the Anishinaabe Nation is much bigger than the Anishinaabe Nation in Treaty 3. Unfortunately, through the treaty process, and through the sort of calibration of these artificial borders, these treaty borders, like they sort of kind of broke down what used to be like one nation into several distinct nations. And so for Treaty Three, we almost consider that to be like a self-containing nation. Um, Partly because like the political context dictates it as such. So with regard to your question, um, I can't say for sure like if other Anishinaabe nations in other treaty territories or across the land have a very similar view, but I do think well, I know they probably don't have an exactly similar view, but like I nevertheless think there are similarities. Like they may not construct it as such, like as into four different orders, but I do think that they believe they have a sacred law that is probably unwritten. And I'm sure that they're thinking of ways on like how to have their laws recognized and affirmed. And I need to point out that it's a fairly new construction of law because like obviously for many generations, like going back to colonial contact, like our people obviously did not have written laws, right? Um, so therefore there is no need to have like a written temporal law, to have like a fourth order of law. It was only after colonial laws were imposed upon our people, and that they've caused so much harm and destruction that we, like at least in the Anishinaabe Nation Treaty 3, decided that there was a need to like codify our own laws so that they could be recognized and understood and by Canadian governments. So, so it's a fairly new phenomenon. So I can't say for sure if other nations in Canada I have the same system or ideas, but that's kind of how we think about it in Treaty 3 territory anyway.
Thank you. We had someone just comment saying we need to decolonize, period, which is true. Um, we have our next question. This is from a UBC student. Um, they said, could you also speak a bit more on the Treaty 3 Grand Council governance structure and context, and any key factors or processes that led the council to begin the process of reclaiming, syncing, and adapting Anishinaabe legal orders in written form?
Yeah. So it's sort of a continuation of that last question, right? Like,
Yeah.
so basically, to kind of reiterate what I said in the presentation, um, our people have always had their own laws. The problem, though, is that in Canada, those laws were never really recognized, right? And in fact, colonial laws were imposed over our people mainly through the Indian Act. And from the Indian Act, Canada imposed other policies that were very harmful to our people. And the big example is the residential school system. And that law was in place for many years, multiple generations, and had like a very devastating impact, like intergenerational trauma, like among many of our members. So the residential school system clearly failed. But with that said, the public education system was not a lot better. I mean, yes, there was less abuse in the public education system, but the fact of the matter is, our people never learned about our culture or our history or really anything to do with our people. We were just not represented in the public education system, and therefore. It just seemed very irrelevant to like many of our people, and it was having corresponding effects, right? Like so, like through um, students dropping out of school and consequently, getting into like addictions or they were impoverished, which with addictions sometimes comes like domestic violence and other criminal types of behavior, right? So it was those factors, like the fact that so many of our people were struggling, and it was recognized that the education system had so much to do with that the leadership in Grand Council Treaty 3 decided that we need to have our own education law so we can teach our own people. And that initiative first came about around 1991. So it's been ongoing for like 30 years. That's when we first realized that we need to like take control of our own people. The problem, however, is it's been a very slow and very long process. Um, but it really wasn't until um, the establishment of the Truth and Reconciliation Commission and the release of their final report, where these matters were then taken very seriously. And I think the government has now kind of shifted its position and starting to see the value of letting Indigenous people, control their own education systems. And so therefore, we're now in a different political climate, and so I'm optimistic that things will kind of change out. But if I may, if I can just kind of uh what do you call that, basically kind of quote the late great Murray Sinclair, like he said, education got us into this mess, and so education will get us out. And what he always says is that the residential school system took generations to really break down our people. Therefore, this process of reconciliation will not happen overnight. It will take generations, but eventually we'll get to a point like where we will heal and recover from that history and hopefully, be much more in line with our traditional values and principles. And so I hope that answers your question on like kind of how uh the Grand Council Treaty 3 kind of first identified this need to have a written education law and, like how it kind of came about.
Yes, I feel like that does, like, especially with the quote that you said with like Murray Sinclair, how education is going to get us hopefully out of this, not only for us, but like even non-Indigenous folks too, you know?
Exactly.
Um, our next question is, has there been any discussion around children in care and education law?
Sorry, has there been any discussion of what?
Surrounding children in care and education law. Um,
Um,
here, I'll just
that's a good question. Let me think about that. Like, I know, for example, there's different sections on like the draft education law, like, and this may not be like directly related to children in care, but like like children who have like special circumstances or special gifts, like there's a section in them like that they will definitely be, from and like provided like the accommodations they need to be able to attend our education system. And if you're referring to like maybe those who are like kind of like adopted out into non-Indigenous families, um, like there will definitely always be a place for those students or children in an Anishinaabe education system. And I also want to make clear that um, like the establishment of such a system does not preclude non-Indigenous students from attending. Like if their parents, are open to the idea of their children learning Anishinaabe culture and the language and are okay with that, like I'm sure they would be welcome into the system. So it's definitely um, there's no like kind of thought of like trying to exclude anyone. It's to be inclusive as possible, but most importantly is to promote the history and culture of our people so that, it can be retained for generations to come.
Definitely. That's very true and very much needed too, like what we were saying earlier, how to sustain that our people and our our ways and whatnot. The next question is what would it look like to create a treaty started from the tribe and not crafted by the colonizing country? Can that be initiated through such an education group?
What a treaty look like that's initiated by the tribe? Is that the
Yeah,
question?
yep, yeah, yep. That's the question. Yeah, sorry.
Um, yeah, it's such a that's a really good question because the bottom of the line, or I guess the bottom line is that the number treaties, for the most part, were negotiated about 150 years ago, and without question, society has changed like tremendously, and therefore, like those original promises and um, just articles of the treaty are outdated, and they need to be renewed. And one thing I actually talk about in my book is the fact that that is one of the glaring kind of mistakes or errors in the treaty process, is that these treaties have never been renewed. Like in my view, these treaties need to be looked at and renewed and renegotiated and like every like 10 years or so. Like basically like it needs to be a generational exercise. Like we need to be able to like look at the treaty, how it was signed, what and to make sure it's still serving, the needs of both parties, right? Both indigenous and non-indigenous. So these trees need to constantly be renewed, and it's not it's not going to be like an easy practice, so to speak, but it's one that needs to happen. And on that note, I want to say that that is what used to happen. If we look at the first treaties that were negotiated between indigenous peoples and colonial settlers way back at the point of colonial contact, like I'm thinking of like the two-row wampum belt, like the Kiswintha, where basically says like that we each have like our own distinct nations, and that we will not try to steer the the rights and governance of another nation. Like we have our own ship and they have their own, and we're going to go along our own self-determined path, that kind of thing, right? Um, like that treaty was renewed like
Mhm.
regularly back in the day, and as an example of that, like that was negotiated way back in like 1613, and in 1764 during the Treaty of Niagara, it was renewed again. And a few times before that even. But like I think that the Treaty of Niagara is an important example because like in some ways that was really the foundational kind of treaty that was negotiated to allow Canada to become the nation it is today. And the Kiswintha, or the two-row wampum belt, was a major part of that. So these treaties were renegotiated like regularly back in the day, and unfortunately, something changed in the 19th century, and my only real explanation for that is that the power dynamics completely shifted. If we look at where indigenous peoples were at when colonial society, of course we had a dominant position, but as more and more of them came through and our people suffered from famine and disease and all these things, and our people just basically became outnumbered, like that power imbalance just kind of shifted how treaties were understood and negotiated. But I would say that yes, definitely these historic treaties need to be renewed and consistently. And like I said, about like every 10 years or so to make sure that they're still doing what they're supposed to be doing.
Mhm. definitely. Like it's good to even just revisit the conversation.
And if I may add one other point, like this idea, like this treaty process, like it's very similar to collective bargaining agreements today. Like if you think about like sports leagues, for example, where you have owners versus the players, like those collective bargaining agreements, they are negotiated like every 5 to 7 years or something like that. And like the treaty is a very similar process. So when we come up to the end date of that particular agreement, we need to come up with like a new agreement. Like, and that, I mean, so it's not like um, it's not something that has not been done before, right? We're not like recreating the wheel or anything. Like it is a process that already has significance and relevance in today's society.
Mm-hmm. Yes, true. We have our next question here. It says, this is just an anonymous person. They said, thinking in terms of reconciliation and reasserting our laws, rights, and sovereignty, do you think all the Anishinaabe nation should spread across the provinces? Like, do you think they should reconnect to the Anishinaabe Nation as a whole, or stay with the artificial borders created by the numbered treaties? Hopefully that makes sense.
That's a good question. Like I think in an ideal perfect world, yes, it would be great to reunite the Anishinaabe Nation as one nation. And and that extends to other indigenous nations, right? Like the Anishinaabe Nation is not the only one that was like really kind of torn apart by the treaty process. Um, like in fact in the plains like it's even more scattered I would say, but like in an ideal situation, yes, it would be good to do that, but on the other hand I think just the social and political history of each like kind of territory has made it very difficult um to do that, because like I think our values have kind of separated a little bit. I think like there's like a fundamental core that still exists, but like every territory is unique, right? Like it has like its own unique needs, and even interests and strengths and stuff that it has to work with. And so therefore, like I think it would be difficult to reunite as one nation again. But at the same time, like I would love to see it happen. Like I just don't know how possible it really is.
Hmm. Yeah, it can be tricky, like when like undoing a system that has already been in place for quite some time. Um,
Absolutely, and if I may, like, and to like think about it, like even in Treaty 3, like we have 28 communities, and like even in that specific territory, it's almost impossible to come up with like a consensus, like where all 28 nations or I mean communities agree like on a sort of path moving forward, right? Like again, and that is because each community has its own needs. And one thing I didn't really mention in the presentation is that um, like this law, like it's not meant to be prescriptive so that like every community is bound to it. Like basically, they would opt into it because they want that. They want it for their community. They support it. And like they're not being forced or compelled to do it. Like if there's an outside community, for example, or if there's any community, even within the nation that wants to kind of go their own way and maybe write their own law or just go about their own way of like dealing with education, then it will be up to them. It'll be their right to do that. But personally, I think there's strength in numbers. So I would obviously you want to work towards consensus, but like the reality is it's difficult to achieve that consensus.
Yeah, yeah. It's a lot harder to do than we think. We have someone wanting to understand something a little bit more. They said, "Can you please help me understand in terms of sources of law? Are you saying that the right to develop this education model is supported by the right in the treaty?" And because the government has failed to fulfill its obligation to deliver a notion of education as desired by the Anishinaabe people. It's also in the chat.
Right. That's definitely part of it. So to me, this all goes back to yeah, the negotiation of the number treaties, right? And that's how Canada ultimately gained its sort of validation as a, as a sovereign nation, right? That's how it claimed its sort of rights and title to the land, right? Through like the extinguishment of our rights and title, right? But in return for that, um, Canada made certain promises. One is that we can continue to hunt and fish. One was that we'd be given annuity payments year after year. One was that, yeah, we get a right to education, and among other things, right? We were promised, cows and plows and other agricultural benefits. Point is, though, like education was one of those promises that we negotiated for and that we were promised that we would get. And then, problem is, shortly after that, the Canadian government basically reneged on that promise, established the residential school system, which we seen was like very harmful to our people. So we have this right to education from the treaty. But because of like the harms and injustices that flowed from the residential school system, we basically acquired more sort of I don't know if rights is the word I want to use, but just sort of I can't think of the right word off the top of my head. But basically from the harms that flowed from the residential school system, we got the Truth and Reconciliation Commission's final report, which produced 94 calls to action. And so there's also calls to action in there that relate to like us establishing like an education system, right? And that basically comes from UNDRIP, the United Nations Declaration on the Rights on Indigenous Peoples, which I kind of outlined in my presentation. Like there's certain articles in there that say that Indigenous peoples have a right to their own education systems using their own governing institutions. So these three documents, like the treaty, the calls to action, and UNDRIP, they all kind of work together to enable Indigenous nations to create their own education system.
I feel like you hit that home this. I think we have time for one more question. The last question is, what advice do you have in bringing equal importance to the Indigenous Language Act? This person is an Indigenous federal worker, and all they hear is the Official Language Act.
What do I have? Um,
What advice do you have in bringing equal importance to the Indigenous Language Act?
what advice do I have? Like my one piece of advice I always share with everyone, like when it comes to adopting new legislation, let's say like Canada comes up with a new piece of a legislation, and here we got like Indigenous Education Act or whatever. Like whatever legislation that comes about that affects Indigenous peoples or is about them or for them, it needs to be written by them and for them. So to me, that is the key piece. Like whatever legislation, and I think the Indian Act is the prime example. So we have this piece of legislation that was written like almost 150 years ago, that's meant to dictate like how we're supposed to like, you know, run our communities and such. Um, but of course, we've seen like how harmful it's been. And that was written by, colonial settlers like way back in the day with no, consultation or process, and that that included us. And so I honestly think it's a very easy fix for indigenous peoples to write their own legislation like that basically mirrors, like what the Indian Act was supposed to do, but instead it's written by us and for us. And we basically tell the government this is how we're going to run our communities. So it's basically flipping the script on like what they say we can do and what we tell them what we will do. So and I would take that approach moving forward with like any piece of legislation that comes out, stating like if there's something that's going to affect our communities, then we need to have a say in how that's going to come about.
That is great. That is amazing. Yes, I think I believe everything you were saying, and I think that's very true. Like we need to be the ones setting our path and guiding them to how we want everything to work with our people. We've seen what they've done with ours, so yes. Do you have any closing remarks before we end the webinar?
No, I just want to say thank you again for, inviting me to be here. And, thank you so much for your questions. Like it's been a learning experience for me too. And so, I hope y'all enjoyed it. And, I look forward to maybe connecting with some of you again in the future.
Yeah, definitely. Well, thank you so much. And thank you to everyone for joining us today. It was great to hear more about Anishinaabe law with Dr. Leo. And it's just been amazing just hearing about the different ways to exercise your rights as for an Indigenous person. Also learning about it from an Anishinaabe perspective. But I just want to bring your guys' attention to our upcoming webinars. We have one on Indigenous public health on November, I think it's 14th. And then we also have Restoring Balance on November 28th. Oh, yeah, the other one was 14th. And all of our webinars are free to sign up for at www.learningscircle.ubc.ca. And if you want to sign up for our newsletter, I think it'll be linked in the chat. And thank you everyone for joining us today. We look forward to seeing everyone at our next Learning Circle. But thank you so much, Leah. It was great having you.
Appreciate it. Thank you. Take care.
Yes. Nice to see you.